Hi, my name's Andrew Kinney. I'm an attorney focusing on Social Security disability practice. I've been doing this work for about 20 years now. Time flies. What I have today is a Social Security 101. As I've mentioned in previous videos, to recap, I wanted to talk about Social Security from the ground up, explain the disability insurance process and SSI. There are different programs that follow the same track. I want to lay out, because there's a lot of misunderstanding about Social Security. Social Security, for example, requires medical proof and evidence of problems. People say whatever they want. They can say whatever they want to doctors, but in the end, objective testing is what allows people to get approved, not someone claiming a problem that doesn't exist. So, although fraud is possible in any endeavor, here, fraud would have to go through doctors, it would have to go through psychologists, nurse practitioners, family members perhaps. It would also have to go through Social Security medical doctors internally at a state agency level and at a hearing level. All told, it is always newsworthy if someone is using the system, but usually and almost always the case, people that have legitimate problems, some are dying before they get to a hearing of problems that seem obvious. So we're going to back off to this. When someone's applying for Social Security benefits, I mentioned in the previous video, Social Security is looking at their monthly earnings, their gross earnings before taxes. Self-employment is a separate situation, but we'll talk about substantial gainful activity today. SGA, that's Social Security's code name for substantial gainful activity. What is it? Well, with Social Security, in order to apply, and starting with application, you cannot be making at SGA level or higher. Okay, so in terms of the amount here, and I have a phone here to tell me each amount, it changes year to year. In 2005 it was $830, and I'm talking about people that are not blind. People that are legally blind have a higher standard, a double standard. It's higher amount allowable for work. But in 2005 it was $830. We're moving to 2009, $980. 2010, $1,000 flat. 2012, 2011 stayed at 1,000, 2012 1,010, 2013 1,040, and now 2014, hopefully this video isn't too dated, is 1,070. It'll go up again in very low increments. The idea here is that Social Security is looking at earnings, gross earnings per month, and they're figuring out if you're making too much. With SGA, it is not only relevant the amount, but also how long you earn it, okay? SGA, there are some legal terminology here. With substantial gainful activity, Social Security makes it's persuasive, it's not conclusive. These are presumptions. Social Security assumes if you make the substantial gainful activity amount going into an application or while an application is pending for 3 months or more, when it's 3 months, within 3 to 6 months, if it's over 3 months but under 6 months, there is they are believing or presume that you're working substantial gainful activity. I may have misspoken and say persuaded. They may presume it's substantial gainful activity. At 6 months or more of SGA level monthly earnings all in a row, then it's conclusive presumption. There's no arguing against the amounts. Now, there are exceptions to the amount. And it's called impairment-related work expenses. Impairment-related work expenses, IRWE. Forget the acronym. The idea is, and the way I see this in practice is, if you're working and you're disabled, but you're working just over the SGA amount, the classic example is, if you're paying out of pocket for prescription medications and you count that up per month, if you're slightly over the SGA amount, you can subtract what you're paying in medications that allows you to work. There are other impairment-related work expenses that can be removed, not insurance payments, not the cost of co-pays, but if you have medications that your doctors are giving you and you need to pay for them, that is subtracted from your monthly earning amount. All this is constructed such that Social Security will allow an application in or not based on this. That's why SGA is important. And secondly, if you are pending an application, what I told our clients, which can be 2 years, if you're able to work 3 months or more and make roughly $1,000 a month, this year, in 2014, it's 1,070. If you're able to make roughly $1,000 a month for 3 months in a row while your case is pending, call us. We evaluate whether you should keep the case going or actually just don't appeal and work more. So again, the idea of working is better. The other thing is duration for SGA, and we talked about that, but I'm going to talk a little bit more about it. Substantial gainful activity is only substantial if it has the amount that we talked about, the annual, each year the monthly amount changes, or usually changes, and also the duration. Again, keep in mind that if you are applying for benefits and you're working SGA, let's say you're a teacher, you work SGA, in the summer you have off. Well, Social Security's medical decisions need to say that you're unable to work for a period of a year. So if you are generally working SGA with a few months off here and there, I would keep working. Get advice from legal counsel on that question. But ultimately here, the duration is that if you are currently having a Social Security claim and you find that you got lucky and got a job that you can do and do it over 3 months in a row, you need to evaluate whether how that affects your Social Security claim. I always, again, tell clients, work if you can. So with this idea of SGA in here, it's important not only to apply, but also during an application. And then, again, when you're getting benefits, then there's a different question, and that is a trial work period. There's a lower threshold monthly amount you're allowed to make. You get information on it later. Don't worry about that. But going in, substantial gainful activity, hopefully that explains a little bit about that. Thank you very much. Take care.